to another episode of Arbitration Life. I am Janette Bryn.
And I'm Hana Dumal.
From October 30th to November 4th, Miami will welcome, it has already been welcoming, legal practitioners from over 130 jurisdictions attending the annual conference of the International Bar Association. IBA's conference is aimed at providing a rich environment for discussion, debate, and learning, as well as the opportunity to develop lasting business relationships and lifelong friendships. Hannah, you're in Miami.
I am in the conference center, in a room in the conference center right now. Yeah, it's been great so far, like to be able to see so many familiar faces and meet new people. So no, it's been great. But aside from the IBA, I'll also be attending the Great Legal Futures event organized by the UK Ministry of Justice and the Department for International Trade on the 2nd of November, so tomorrow. And I'll be speaking as a panelist on developments in arbitration insight from around the world. So this year's conference featured more than 200 sessions, and I've been to a number of them. It's been extremely interesting. And it's varying widely from core substantive committee sessions that cover most sectors and practice areas to more specialized topics. So for example, today I saw a session on ESG and diversity, very, very interesting. So yeah, other topics for the committee sessions are ethics, the future of the legal profession and the rule of law and human rights. And because we'll also discuss and have been discussing the ever-changing role of the legal profession in a series of showcase sessions. Wow,
sounds like indeed a very rewarding, well, two conferences back to back. So our guest today is actually the vice chair of the IBA Committee and former co-chair of the IBA Arbitration Committee's ESG Subcommittee. She's also a commercial litigator with over 15 years of experience and specific expertise in international arbitration, having substantial experience in handling cases involving issues of public law, constitutional law, and human rights law, and has sat as arbitrator in a significant number of arbitrations, either as sole or co-presiding arbitrator.
Absolutely. And she was actually the first arbitrator, the arbitrator in the first BVIC administered case.
Right.
And she has litigated a broad range of commercial disputes, including those in the energy, telecoms, financial, construction, manufacturing, and shipping sectors before the English courts, also courts in the Commonwealth, and arbitral tribunals under various rules. In addition to her role as vice chair of the IBA Arbitration Committee, she also serves on the ICC UK Selections Subcommittee, on the Arbitration Committee of the Lagos Court of Arbitration, and she's a board member of the ILN Academy. She is well known in the arbitration community, having been recognized as International Arbitration Junior of the Year by Chambers and Partners in 2021, a global leader for arbitration by Who Schools Legal, and also named as a star at the bar. Please welcome Angeline Welsh.
Well, hello, Hannah and Angeline from Miami.
Hello, yeah, from IBA. Everybody badges. We found a conference room, so that's great.
Yes, so great we were able to do this today. So not going to waste any time because Angeline and Hannah, I know you guys have some, meetings that you need to get to over there in Miami. But Angeline, such a pleasure to see you again. Please share with us how you got started in arbitration, and did you choose arbitration or did arbitration choose you?
That's a really good question. I think arbitration chose me rather than the other way around, I would say. And I was just chatting to Hannah before we got started, saying that I now feel quite old because I think things have changed quite a lot since I started out. So I started my career in a major international law firm, and at that time the way in which the law firm was organized is we just had a litigation department. We didn't have specific specialized groups within that department, and I actually started out doing quite a lot of judicial review cases, But the partner I was working with at the time, who's sort of renowned for, the judicial review was not in England, it was in actually in the Caribbean, and using English law principles and so forth. But the partner I was working with was used to dealing with offshore jurisdictions, let's say, and it was an arbitration specialist. And so what he did was he just kept putting arbitration clauses in all of the main relevant agreements for my clients. And then eventually, or not even after that much time, disputes obviously arose, and then they were in arbitration as a result of all of these clauses. And I just started doing a lot of arbitration, and it sort of moved from there. And as things developed, the law firm, and I think this is very typical now, law firms then became more specialized in terms of what they did. And so, before long, before I knew it, I was in the international arbitration group of, one of the biggest arbitration practices internationally. And that started me on my sort of legal journey in the world of arbitration, really.
Nice.
Yeah, and it's so nice. It's actually also in arbitrations involving the Caribbean.
Yeah, exactly. So this brings me right back to, the association with BVI brings me right back to my roots and continuing work that I do actually still in BVI, before the BVI courts, and in Belize and other jurisdictions around the Caribbean. So it's a region which is really close to my heart.
Oh, this is great, Vida. So I was so happy to have you today. So, and you just mentioned that earlier, actually, but that's our second question. How has arbitration changed from the time that you started compared to now?
One of the things that I quite often get asked by people who are starting out in their career, how do you get into international arbitration? Because, it is a fantastic career to be in, and quite glamorous, I think, from the outside, particularly at the very beginning of your career. And honestly, I have quite bad advice, because as I just explained to you, it's sort of found me rather than the other way around. And I think that is one of the major changes that you see in international arbitration now, that it just has a lot more specialists in the field. And the other major thing is that, as I was explaining a moment ago, when I started out, international law firms becoming a lot more specialist in arbitration. What I think you see now, and really has changed over the last 5 years, is it's not just the international law firms who are doing arbitration, it's also, quite rightly, regional law firms who have their own arbitration specialists who are doing more and more arbitration. So it's become more specialized, I would say that, but at the same time, it's become more diverse in that there is a greater awareness and appreciation and, frankly, skill set from around the world. So that I think has sort of been the major changes in the last sort of 10 to 15 years.
Yeah, definitely. So practicing both as an arbitrator and as counsel, how would you say your role as an arbitrator enhances your role as counsel, or vice versa?
I think this, I was just saying to Hannah, I think this is a really great question, because I think my arbitrator practice really has enhanced my counsel practice. And because you are in the, and I think that's really, two aspects. The first is that being in the position of decision maker, you know what you need in order to decide a case. And so you're able to do that as counsel. You're able to say, it is about the rationalization of issues. It is about understanding what level your tribunal is likely to be at when they're deciding the case, which is sometimes quite hard as counsel to appreciate, because you've been living with the case for 2 years or however long it might be. And with the best will in the world, the tribunal is just not in the same position, because they haven't been able to sit in meeting rooms with clients for 10 days and sort of ask them all of these questions. They're presented with a package of information. So it's partly about understanding how you need to educate the tribunal, also partly about understanding what are the flashpoints likely to be for the tribunal, what are the things that they're going to be interested in, what is the things that they're going to be concerned about. So that I think it really is very helpful from that counsel perspective. And I think the other sort of major aspect of it is that, you as arbitrator are used to controlling that room.
Yeah.
particularly if you're sitting as sole and presiding, which I do fairly regularly. And so, you just feel as counsel, you're on the same level as the tribunal because you've been in that position, you know what it's like, you have a better understanding. And so it's also a sort of, makes you feel like you have a very strong and robust seat at the table, if you like, as counsel. So it's those two dynamics, I think, which has a major impact.
Yeah, very interesting. Mm-hmm.
And now, Angeline, what would you say is the most useful skill to have as a lawyer? And you can go into more details as you practice as barrister and advocate. And maybe could you please also tell us how we can develop that skill?
Okay, so for this question, I think probably being a lawyer has obviously lots of different skill sets. So I think what I'll do is focus on role as an advocate, either written or oral advocacy. And I think one of the things that's really important to that role, not necessarily the most important, but there are a number of aspects of that role which are really important. But one of them, to my mind, is the importance of logical structure to your legal arguments. And what I mean by that is, in order to really understand your case and be able to present your case, you need to have a clear understanding of the legal roadmap of to get to the end result of what you want to be. And that is sort of understanding what the facts are, what the factual weaknesses are, your legal case and the legal weaknesses. And if you rationalize or spend a lot of time rationalizing the structure of your case, as it were, I think that really helps you. And it helps you because, one, you're able to present this sort of decision-making process to a tribunal, which, as discussed just now, is really important. But I think the other thing that it helps you to do is to work out in your case what is relevant and not relevant, because sometimes there will be issues which, they might have broad relevance, maybe they're prejudicial or something like that, or there may be issues which are actually just not relevant, the client feels are important to them. But you need to work out whether, you need to streamline things basically, and you need to know in your own mind as advocate, what are the points which you really need to nail, and what are the points which, you can press, you can let go of, or if a tribunal has a particular issue with a point, what's the way around that? What's your alternative position? So that, to my mind, is the most important thing. And how can you do it? Well, I think it's about the rigor of sitting down and doing a roadmap or an A4, or working out how the various different legal and factual issues gel together in a jigsaw.
Thank you. I like the roadmap.
The roadmap analogy, yeah.
Yeah.
So, well, one of the reasons you guys are in Miami is for IBA. Angeline, as well as being a former co-chair or co-chair, you're actual co-chair or former co-chair of the IBA Arbitration Committee, ESG Subcommittee.
Yeah.
You are well-versed in handling cases involving human rights issues. Would you say there are advantages of using arbitration as a method to resolving human rights disputes? And if so, please share with us some of those advantages.
So I think I'm currently vice chair of the IBA Arbitration Committee, which I'm very privileged to be in that role. The last 2 years, I co-chaired the ESG subcommittee. And one of the things that we did on the ESG subcommittee is conducted a survey of in-house counsel and businesses to establish what are the ESG clauses which they're tending to find in their contracts, and also what are the typical dispute resolution mechanisms that they're seeing. And I mean, using international arbitration to resolve human rights disputes, there are the Hague rules now, which many people will be aware of, which were developed in the last few years to specifically cater for business and human rights disputes. So there is a set of rules there. What I found particularly interesting about this survey was, and there are lots of different issues which you could discuss as to whether or not arbitration is suitable for human rights disputes, or in particularly what I'm talking about is business to human rights disputes here. I think probably haven't got time to go into them, but one thing that I want to highlight from the survey, which I thought was really interesting, is that what in-house counsel were telling us is that actually confidentiality would be a reason why they may use arbitration to resolve some of the ESG disputes which are coming up. Now that in some senses you might think is a slightly controversial proposition, because when we are looking at human rights cases, and particularly human rights cases in the context of ISDS disputes, the trend has actually been towards transparency rather than confidentiality. And, that is the sort of, I think I'm right to say it's the default position to the Hague Rules. So there's a trend towards transparency for these types of disputes. But in the business to business context, or in victim to business in particular, it seems to me that there's something, one thing, an interesting question perhaps we ought to debate is, if businesses are only willing to assume responsibility for some of these obligations, or to assume responsibility for any claims which may be made as a result of these obligations, because any disputes arising out of those obligations will be resolved in a confidential arbitration process, then it may well be that one of the things that's worth giving up is transparency in order to get the assumption of these obligations by companies. But that is in some senses, some may regard that as a trade-off which is too far. But the case under the Bangladesh Accords with the PCA, which was a major sort of platform for human rights disputes, they were all held confidentiality. So, confidentially. So an interesting example, I think, of the way in which that's working in practice.
Yeah, thanks for that. And thanks for clarifying your role. And that's an interesting point, the difference between transparency or considering giving up confidentiality and vice versa. That's quite interesting, a point there. Thank you for that.
Now, my next question, it's actually to follow up on those ESG disputes.
Yeah.
But yeah, it's a different question. How can parties benefit from the use of arbitration in resolving those ESG disputes?
I think the primary, the primary benefit, which was identified in our survey, was the confidentiality one, companies were quite interested in arbitration, but I would say primarily as a result of that. But there are, as I said earlier, there's a number of different issues which arise in the context of ESG type disputes, and I think it is probably important to distinguish between, on the one hand, business to business disputes, so where you have supply agreements, and we may see more and more of that because we now have a draft European directive which looks at mandatory due diligence obligations for companies for human rights and environmental obligations. So you may see more and more of that. To me, that's less controversial to have that resolved in a confidential process, and there's less issues with using arbitration because fundamentally those types of disputes are based on contractual arrangements, and so arbitration lends itself very well to that sort of thing. What is more problematic is where you have victims to business human rights disputes, because there's the confidentiality issue which we've just discussed, but there's also other issues like funding. So where arbitration is obviously a private process which the parties typically pay for. So how does how do you facilitate that if the victims of human rights disputes don't have any funding? That's another sort of obvious example. But there are some real world examples of where this sort of thing has worked. So there was an arbitration scheme set up by, I think, News of the World as a result of the hacking claims several years ago. So in order to just filter the number of claims and expedite that process, and News Corp, or whoever was the relevant legal entity, paid for that. So it it's possible, but you know, you can't quite see yet that arbitration is necessarily going to take off to resolve those types of disputes just yet. But you know, things may change.
But at least business to business is something that
Business to business, I think there is, you know, I think the thing about human rights you've got to think about is that typically human rights claims were usually brought by victims against the state because it was state assumed obligations. But with the UN Guardian Principles and various other mechanisms, you know, you see states trying to move, or the trend to move some of these obligations onto companies. That's what we see with the EU directive, and there's various modern slavery legislation and so forth. And so it may well be that we'll see an increasing number of those types of disputes as the regulatory landscape changes and companies have to assume more responsibility. And one would think that a major driver in that would be the climate crisis.
Yes, absolutely.
Yeah. Can you share with us, Angeline, an experience that has been most impactful in your career?
Well, I think rather than identify one particular experience, I think it's probably quite important. I think it's important to talk about the role of mentorship. Because certainly I know when I started out in my career, I had one or two colleagues at the law firm at which I worked with who were really instrumental in introducing me into the world of arbitration. And as many people will know, to sort of get established in arbitration, part of it is about building your network and building your network in an international stage. And I think, you know, for people just starting out or junior members of the community, sometimes that can be really intimidating. And so I think in terms of what I think really helped me when I started out was those sorts of mentor relationships. So being able to find someone who understood the world and could introduce you into the sort of broader arbitration community, but also making sure that you build your network of peers at a junior level by attending the excellent junior arbitration organizations, of which there's the IBA Arb 40 I'm a former co-chair of here in Miami, but they're also, you know, young organizations with many other arbitral institutions. And I would say that now, sort of 10 years, 15 years on, however long it may be, some of the people that I met through those organizations are you know, key parts of my network, and also, you know, genuinely very good friends now. So that's what I would sort of say has really transformed my experience of this particular career, and the advice I would give to anyone who's starting out in it now.
This is a great advice. Like the best advice.
Yeah, I mean, it's just, and also, you know, I shouldn't say this, but quite often, well, I'm saying this now, and which will be broadcast on YouTube, but you know, young sessions are genuinely sometimes some of the best sessions, because you have all of these new creative ideas and issues are properly addressed and discussed, and also it's great fun. So definitely that is something which is a must if you're starting out.
Yeah, agreed. Thanks for sharing that.
Now, can we please ask you to share another pearl of wisdom, because this was clearly a pearl of wisdom.
About that, yeah. I'm going to go back to advocacy again for my pearl of wisdom. But it doesn't come from the world of arbitration, but I think it is applicable. I remember being quite a junior lawyer and going to a meeting with a quite senior barrister who's now a judge. And it was on a case which I think there was some human interest element to it. It wasn't a proper straight commercial case. I can't remember whether we were doing it pro bono or not, but quite possibly. And we went into the meeting with the barrister, and the client sort of poured out their heart of the great injustice which had been suffered to them, and all the reasons why they thought that the court should act to grant their claim. And the barrister just said, okay, that's really interesting. I've got all of that. That's the will. Now we need to find the way. And that distinction between will and way is so important, I think, when you're thinking about organizing a case, particularly thinking about your advocacy. Someone needs to want to find for you, right? You need to think about why it is that someone, a tribunal, a judge will want to find for you. What is the will for your case? What's the broader sympathetic picture that you want to paint to get someone to think that actually you are the wronged party? That's the will. But then you need to look at the roadmap that I just talked about earlier, to give the court, this is why, these are the logical steps why you also need to find for us, or you can find for us, and this is how you do it. So you ought to find for us, and way, this is how you do it. And I think that is sort of pearl of wisdom that's really stuck with me ever since. And I always think about when I'm preparing my own cases and I'm sort of very boringly tell everyone else about. So yeah, that's it. It's not my pearl of wisdom, it's someone else's that I've adopted.
It's yours now.
It's mine now. I'm making it by disseminating it to my pearl of wisdom.
No, it's not boring at all. Like, and I love how you explain it. Like, it's the roadmap to find your way. It's quite poetic, and it.
There was I did a secondment to an NGO when I was a trainee, and I always remember she was a barrister, quite famous actually in the UK eventually, but she always said, you know, if you think about, she was talking in the context of an instruction which would go to a barrister, but it would apply equally to a skeleton argument, I think, or written submissions. You basically are almost think about it in terms of you're writing the award or you're writing the judgment. You're basically showing the court how they need to, these are the logical steps that lead you to the end result, which is what I want for my client.
Absolutely. That's a great advice too.
Yeah.
So they can basically just the judge or the arbitrator use that to write the judgment or the award. No.
Yeah.
Absolutely.
Yeah, exactly.
So Angeline, we've come to the end of our Arbitration Life interview today, just in the nick of time for you guys to continue on your busy day, but we cannot let you leave unless we ask you our bonus question.
Oh my goodness.
My goodness.
I know, I don't know, bonus question. I'm very nervous now. What is it?
So what we love to know from experienced arbitrators such as yourself, what is that theme song that gets you going, gets you started?
Oh my goodness. Oh my goodness.
You got a big hearing, you need to be pumped up and energized.
Hyped up. Oh my goodness. I don't know. I'm gonna have, this is when I go blank. I listen to a lot of music. I listen to music when I work the whole time, but I can't, I can't think of one there is one that there's a Lizzo song.
A Lizzo song? Yeah,
there's a Lizzo song which is really hyped up, but it's from about 2 years ago, and I can't remember the name of it.
They all hype you up, basically.
I know, all of her songs are.
I mean, if you want to
I'm really curious now, which Lizzo song?
I'd have to look it up. But then there's endless amounts of songs, but I just remember that's a sort of, was it about looking at your nails or something like that? You must remember it.
Oh yeah.
But anyway, that is
we know which one. We know.
It's kind of like I'm in charge. Yeah, that's a hyped up song if you want one.
That's a good
all right. So we got you, Lizzo fan. All right. Thank you so much, Angeline.
You're really welcome. Thank you for having me.
Yes, this
nice
has been great.
Hana in Miami.
Yeah, and definitely we look forward to having you in BVI with us.
Yeah, absolutely.
Before too long. Yeah.
But yeah, first time we met in person after collaborating.
Yeah. It's nice.
Before on Zoom, it's nice.
All right, nice. All right, so that is it. And have a great day, you guys.
Very much, Angeline, for joining us today for another episode of Arbitration Life.
For more Arbitration Life, please be sure to hit the subscribe button, plus follow us on LinkedIn and Twitter and Facebook at Arbitration Life.